of the 5th District of the State of Florida is now in session. The Honorable John M. Harris, Judge presiding. All persons having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
All right, good morning. Welcome to an oral argument session here at the 5th District Court of Appeal. The Marshal has introduced me. Let me introduce the other members of the panel. To my right and your left is Judge Eisnagel, and we're happy to have visiting with us this week from the Ninth Circuit, Judge Patricia Strobridge as an associate judge. If you have any electronic devices, please turn those off at this time or set them on silent or vibrate. These are civil cases. Each side will be given 20 minutes for their argument. If you're the appellant, you can reserve some of that time for rebuttal if you like. I will set the rebuttal time at 5 minutes. If you'd like a different amount of time, please let me know and we can make those arrangements. And first case we'll address this morning, excuse me, is case 18-2481, James Wardell versus Fifth Third Mortgage. Good morning.
May it please the court, good morning. The 5 minutes is fine for rebuttal.
Okay. Whenever you're ready, counsel.
My name is David Weisbrod, and I represent appellants Jim Wardell and Michael COURSON. This is an appeal from what we believe to be an improper granting of summary judgment in a mortgage foreclosure case. We've raised three issues pertaining to the procedural irregularities and substantive decision of the lower court. Two of those three have been conceded by the appellee concerning the procedural decisions of the circuit court. They have still, of course, maintained that affirmance is appropriate, and we strongly disagree. I think a time frame would help the court's analysis in this case pertaining to the summary judgment. So in December of 2017, the appellee files its motion for summary judgment, but without any supporting affidavits. In March of 2018, the appellants file an amended counterclaim. Appellees respond to that, asking for it to be dismissed, and in May, serve a notice of hearing for June 7th for the counterclaim. Excuse me, in April. In May, unilaterally, they amend that notice of a hearing to include the motion for summary judgment and attach their affidavit in support of their motion. The hearing is set for June 7th of 2018, and on June 5th, appellants file their oppositional affidavit. They file it through the e-portal with the court, and they email it upon the lender, the appellee. At the hearing on June 7th, a question arises as to whether or not the affidavit is timely filed under the definition of the term delivery. Now, as we stand here today, email delivery...
They've withdrawn that argument, right?
I'm sorry?
They've withdrawn that argument.
They did indicate that they have abandoned it, but it's still important to understand in the context of what then occurred, because the court is unable to conclude the hearing on June 7th. It's incomplete, it's truncated, it's abbreviated.
When you say truncated and abbreviated, did you get the full 15 minutes that was scheduled?
The notice of hearing didn't indicate the amount of time. The court, at the beginning of the hearing, at page 3 of the transcript, says you're only set for 15 minutes. And I don't think that'll be enough time for us to get through the issues in this case. So the court gave them the time that it had available, but clearly was unable to complete the proceedings.
So trial counsel went to the hearing without any idea how much time was scheduled?
According to the notice. The notice did not have any time. And it's one of the very first issues that
The record doesn't demonstrate whether counsel knew that they had 15 minutes or not.
It does come up at the very beginning of the hearing. The notice of hearing doesn't reference it, I think because of the type of hearing calendar that it was. When they arrived there, they knew it would be 15 minutes only. But of course, they didn't set the hearing. The hearing was set by the Lenders Council for both of their motions, the motion to strike the amended counterclaim and the motion for summary judgment. And so,
How much of the 15 minutes allotted was spent on the motion to dismiss the amended counterclaim? Was it even addressed?
it was addressed. Everything was addressed quickly. There was some minimal amount of time spent on it. I think not enough in the sense that when you look at what the court ultimately ruled in July, or excuse me, later in June, in determining that the counterclaim, that the argument that the appellants were able to file an amended counterclaim without leave of court or consent of the other party was invalid because there had been a pleading addressed to it in the form of a motion to dismiss. That ruling, we think, is clearly erroneous, and again, the appellees have acknowledged that.
Had the counterclaim been previously dismissed with prejudice?
It had. This counterclaim was completely different.
Was it completely different? I mean, some of the counts were the same.
The factual basis was almost entirely different. There was a new count based upon the Consumer Collection Practices Act, and there was one count that sounded in the same cause of action as the original counterclaim, but based upon different facts. And the easiest way to make that determination is to look at the factual allegations in the amended counterclaim. They occurred, the events occurred after the filing of the initial counterclaim. They could not have been raised at the time of the initial counterclaim because the facts didn't exist regarding the lender's activities and actions in connection with the property.
Your brief suggests that the counterclaim should have been treated as affirmative defenses.
For purposes of considering whether or not there was a genuine issue of material fact, we believe that the allegations within the amended counterclaim, which should not have been stricken by the court, could have been considered by the court in making a determination as to whether or not there were genuine issues of material fact.
I don't remember. Was the amended counterclaim verified?
I believe it was, but
Okay, I can't remember, but just asking.
But it raises attempting to determine whether or not there are genuine issues of material fact is a very difficult process in this case because of the way the hearing occurred and then the submissions that the appellee sent to the court afterward. And so you have a situation where when the court ultimately enters its ruling, in granting summary judgment, it first says, I'm not going to consider appellant's affidavit that was filed on June 5th in opposition because it wasn't timely delivered. So she strikes that from consideration, and we now know that that was improper.
What in the affidavit would have created a material issue?
Well, I think there were issues regarding the provision of notice. I think there were issues, well, let me delve into the notice a little bit more. So the property was a second home in Crystal River. The appellant's address for notice purposes was his residence on Delaware Street in Tampa.
But the address that it was sent to was his business address, correct?
Correct.
And in the affidavit, he didn't actually say that he didn't change the address, that he didn't recall changing the address.
That is correct. That's exactly what it said.
Did it really create an issue of material fact?
Well, the notice provision itself says that it has to go to 719 Delaware, and it has to come from the lender. And when you look at the one affidavit that was filed prior to the first summary judgment hearing, they don't say that we got written notice from the appellants, from the borrowers, to change the address. They say that there was contact of some sort. And never at any time has this written notice been produced. And so the very specific requirements in the lender's own note and mortgage regarding who will send the notice and where they'll send the notice to and how notices are to be received from the borrower, all of that is not established by the bank's affidavit.
But now you're talking about the bank's affidavit. We're asking about your affidavit.
Well, but he alleges in affirmative defenses, I believe it was 8, 9, and 10, that the notice provisions were inadequate. And then in the affidavit, he does state that he did not receive the notice and it wasn't sent to his house.
Well, he says he didn't receive it at his home.
Correct.
He doesn't say he didn't receive it, right?
The burden is to show that it was sent to the proper place.
But whether he
It's not-
received it
again,
or
you're-
not isn't the issue, is it?
Again, you're referring to the bank's affidavit. That's a different issue. We're asking you about your affidavit. How did your affidavit create an issue of fact?
Well, again, as to the notice, the lender doesn't send the notice. The lender is supposed to be Fifth Third Bank. The notice that was sent does not come from Fifth Third Mortgage. The notice does not come from Fifth Third Mortgage. It either comes from Fifth Third Bank or Fifth Third Bancorp. It's hard to tell, but that's their documents. So the notice itself is sent from someone other than the lender listed in the documentation. Again, it's in the Draves affidavit. I'm sorry to digress a little bit. They say they were contacted, but again, there's no letter was ever sent. Mr. Wardell's affidavit says they don't recall, but no letter was ever produced by the bank, and a written notification is what they require.
So, counsel, you keep going back to the bank's affidavit. It sounds like you're conceding your affidavit doesn't raise an issue of fact. You're
No.
challenging the sufficiency of the bank's affidavit, correct?
Both.
Well, then tell us how your affidavit raises an issue of fact.
Because, number one, because of the notice. Number two,
How? Tell us. Don't just sort of conclusory say the notice. What did the affidavit say that raised an issue of fact?
May I?
Sure.
Unfortunately, I need these.
Counsel, if you'd like, perhaps in rebuttal, you can look that
Okay.
up and then tell us in rebuttal.
It's based upon the notice not coming to his house. It's based, which incorporates the affirmative defenses. It's also based upon the counterclaim, the facts alleged in the amended counterclaim concerning the bank's actions. So,
Tell us about the request for admission. Those are important, right?
they are, because it's pretty much the entirety of the appellee's argument that because there were requests...
If you can't get rid of the request for admissions, you lose this appeal, right?
The case law seems to suggest that in Singer. But in the motion for rehearing that appellants filed after the motion for summary judgment was granted, they told the court that there had been a tolling agreement among the parties. And
That
so
agreement ever reduced to writing or verified by an email or anything else to support that this agreement was in place?
there was, but they were not included.
Is it in the record?
It's not.
Well,
We tried
how-
to supplement the record, and that request was denied. Because the issue,
Is it in the trial court record?
in the motion for rehearing, the allegation is made.
The allegation, is there anything, is there an affidavit to say it? Is there, did the motion attach an email from opposing counsel?
It did not. It just
So
asserted.
essentially, you just have a bald assertion in a motion for rehearing.
Well, by an officer of the court who is saying that this was never an issue before. Now, this does go back to the timing, because this is, again, a submission that is sent to the court after the June 7 hearing, and appellants are anticipating that there's going to be another hearing because of how incomplete the first one was. That is something that the trial court made repeated reference to, and as a matter of fact, at the very end.
But did that stop you from attaching an affidavit or an email from opposing counsel in the motion for rehearing, something to substantiate the allegation?
Well, I don't think it stops them, but they're expecting there to be another hearing where all of this can
Not
be
at the motion
fleshed
for
out.
rehearing point, they're not.
Correct. At the motion for rehearing, at that point, they're just making an assertion that there was an agreement among the parties regarding the tolling, and it's never been denied.
Was there a discussion of the request for admissions at the what you referred to as the truncated hearing?
No, Your Honor. And that's why it was one of those things that was submitted post-hearing by the appellees. It was not part of the initial discussion. So in a sense, so again, you have this situation where the trial judge is not considering some of appellant's materials, but considering all of these other materials that the appellee has submitted late in time, and there's no opportunity to respond to that despite a good faith belief that the court's going to hold another hearing.
So prior to the actual hearing, plaintiffs had no idea that, or defendants had no idea that the plaintiffs intended to rely on those unanswered requests for admissions.
Correct, and why would they? Because they were under the impression that there had been a tolling agreement regarding discovery. So, again, at the end of the hearing, counsel for the appellants says, I'll be happy to schedule additional time so I can make my complete arguments. And the trial court's response is, I understand. And that comes and that's at page 26 of the transcript. That comes.
Just so you were, counsel, you're about 30 seconds into your rebuttal.
Oh, well, let me then have a seat. Just finish up by saying at page 23 of the transcript, the trial judge has said, I will look at everything. I will take a look at your affidavit, and then does not.
May it please the court, Michael Muniz on behalf of Fifth Third Mortgage Company. I think all of the questions asked of opposing counsel here were right on point with the issues that have been raised. And for what it's worth, I do agree with the references to dates as to when things occurred made by my opposing counsel. However, the question of the notice, the notice was indeed sent, and at no time did the defendants deny receiving it at the business address that it was sent to. Now, where would the lender have gotten that business address if not
Counsel,
for...
it's summary judgment. Why do they have the duty to deny that they received it?
Actually, they...
You're the movement, right?
Correct. Truly, they don't. They don't. But the fact remains that behind the scenes, you've got certain actions being taken, and you have to, I think, presume that the lender, Fifth Third, got that information, the new address for notices from the defendants.
We have
Don't
to
you have an
assume it?
obligation to prove the fact that that address was changed? Is a screenshot from the bank's own computer proof that you were notified to change the address from the property address, which is the appropriate notice address under the mortgage, right?
It may not be conclusive proof, but it is some proof because it's a business record maintained by the mortgage company.
Is it sufficient to overcome the affirmative defense when all of the inferences have to be given in favor of the non-movement?
When you look at the affidavit, that they filed 2 days before the hearing. That affidavit simply does not establish a genuine issue of material fact. Even if you look at the affidavit where it discusses the notice.
That may well be true, counsel. We're asking you about your affidavit at this point. You were the movant, you had the burden,
Okay?
right?
Yes, yes. To
So if your evidence was insufficient, then it doesn't matter what the other side does, right?
Correct, but it wasn't. It was indeed sufficient to establish there was no issue of material fact in this case because
You didn't need to establish that the address had been changed in a writing. The mortgage documents require a writing, correct?
they do, but like other aspects of the mortgage instrument, they can be waived. They don't necessarily have to hold true for every single aspect of it. And here it is, it would be the lender who's giving up a right to insist upon a writing. So the fact remains that they simply didn't come back to rebut the affidavit plus the request for admissions that you discussed earlier. The request for admissions, the fourth one, admitted that he had received the notice.
Is there anything in the record indicating that there was an agreement on discovery?
No, there's nothing in the record to indicate that. And I searched the record, and I can say that with confidence. There's nothing there.
Other than the statement in the motion for rehearing?
Right, other than that.
When did the plaintiff first indicate an intent to rely upon those unanswered admissions?
I believe it was in the supplemental memorandum that was submitted to the
After the
court.
hearing?
After the hearing, yes.
So prior to this hearing, the defendants had no way of knowing that the plaintiff intended to rely on the unanswered request for admissions?
Well, you have to, I think, impose upon the parties to know what's in the record at the time a motion for
Counsel,
summary.
that's not what Rule 1.510C says, right? Rule 1.510 on summary judgment?
Yes,
Don't you have to notify the other party what your summary judgment evidence is going to be?
yes,
Right.
yeah, that is required.
Did you do that?
That wasn't contained in the initial motion itself, no.
Right.
We can.
You didn't comply with 1.510C.
On that aspect, no, no. That
You
should
kind of
have,
asked us in your brief to hold the defendant strictly responsible for complying with the request for admissions rule of procedure, while at the same time, you didn't even come close to complying with the summary judgment rule. Why should we hold them to the rule and ignore the bank's failure to follow 1.510?
well, it wasn't a complete failure because it was contained in the supplemental memorandum.
That's not a motion.
Pardon?
That's not a motion.
Correct, it's not a motion. But-
And they have a right to a hearing, right?
I'm
So they would have a right to a hearing on summary judgment. So if the hearing had already taken place, would the plaintiff not, or defendant not have a right to a hearing at which they know what the evidence is that's going to be presented against them? Isn't that what the rule requires?
To be candid, yes, I think, in retrospect, the trial court should have held a subsequent hearing, much as the defendants claim they expected. But that did not preclude them from filing additional affidavits or supplemental
I
memoranda.
have no idea that you're going to argue and the judge is going to rely on these unanswered requests for admissions. The whole purpose of putting it in your motion for summary judgment is so they can then come in and say, well, here's the email showing that we had this agreement for an indefinite extension. They were deprived of that, and then the judge in her order relies on these unanswered requests for admissions. They never knew that was coming. Doesn't that fly in the face of the spirit and the intent of 1.510?
Yes, it does.
That's a problem,
To be
isn't it?
candid. Well, it's a problem if you totally ignore the fact that they're responsible for knowing what's in the record.
Well, that's not in the record. Where is there anything in the record about, don't you typically file a motion to deem these admissions admitted for their failure to comply? Isn't there typically a hearing and an order that says, okay, the defense did not comply with or did not respond to the request for admission, so they're now deemed admitted? That's typically, I mean, it's not required by the rule, but it always happens that way.
I would agree with Your Honor, yes.
And that wasn't done in this case. I mean, there's nothing in the record. You're saying they need to rely on what's in the record. There's nothing in the record that shows you're going to rely on these requests for admission. The requests for admissions aren't even in the record. You served them, I don't remember when.
Yes, they are in the record.
So let's talk about that. You say that, I still don't know that if you're denying that this agreement ever occurred. You're just saying there's no proof in the record that it did. But there's all the discovery that was served by your client on whatever the date was. And then as far as discovery, nothing. I mean, there's crickets. There's no motion to compel. There's no response to anything. There's no motion related to discovery after they were served. Isn't that consistent with their position that, hey, we had an agreement to hold off on discovery indefinitely? That's in the record, right?
Again, to the best of my knowledge, there's nothing in the record to indicate that there was this agreement among the parties that they
Then
could...
wouldn't the bank have filed a motion to compel or something related to discovery at some point before summary judgment if there wasn't this agreement? I mean, that's at least consistent with their position, right?
Yes, that wasn't done in this case. But I can tell you with assurance that the record at pages 347 to 394, the record contains the request for admissions in those pages.
And the judge in her order granting the summary judgment, because it was brought to her attention in the supplemental memo, she says, oh, by the way, they never responded to the request for admission, so I'm going to rely on that as well. I looked through the file, and no response was ever filed. Well, they're not required to file a response. How would she know that no response was ever served? And that's all the rule requires. They got to serve an answer to the request for admissions.
I'm sorry, am I misunderstanding you saying that they were not required to file a response?
Does the rule require them to file a response or serve a response?
I believe the word is serve.
Right.
Yeah.
And the judge said no response was ever filed. Well, it wouldn't be filed.
Well, in most cases, at least from my experience in 20 years, parties do file the responses when they're responding to discovery, whether or not it's required or not.
Well, usually they would serve it back to you, and then you as the party that served those requests would then file the responses.
Right, right.
Counsel, is that argument raised in the initial brief?
Which argument?
The argument you just discussed with Judge Harris.
In our answer brief?
The lack of response. No, in the initial brief. Appellant's initial brief?
Oh, appellant's initial brief. No, I don't believe it was.
If counsel had argued in the initial brief that Rule 1.510 required the bank to put them on notice that it was going to rely on a second affidavit that you filed and also the request for admissions, then we would have to reverse this case, correct? Because you didn't comply with 1.510.
I would agree. I would agree. But that's not what happened.
Well, it is what happened below.
Well, when you say...
You didn't comply with 1.510, very clearly.
Well, you'd have to ignore the subsequent filings to reach that conclusion.
That's the whole point of 1.510. You can't have subsequent filings under 1.510, right?
Well, but the peculiar circumstances of this summary judgment hearing lent itself to subsequent filings.
Well, maybe so, but the peculiar procedural posture of the case doesn't comply with 1.510. And I don't see an exception for odd procedural postures of cases in Rule 1.510. Do you?
No. And I think you need to consider the equitable principles to consider what's equitable here. If you look at the record...
Well, don't you think it's equitable for everybody to know what's going to be relied upon at the hearing for a motion for summary judgment?
Yes.
And in this case, that since Rule 1.510 wasn't complied with...
Well, again, you have to ignore the rest of the record to reach that conclusion. And
explain that. How do we have to ignore the rest of the record to conclude that Rule 1.510 was not complied with?
Well, two aspects. One, you have an incomplete summary judgment hearing. We all know that. I don't think there's any dispute about that. It was incomplete at the time it was held. June 8th.
So you were at that hearing, right?
No,
You were not, okay.
no, I was not involved in the trial court. No. Trial counsel handled.
But everything you're supposed to do in Rule 1.510, the stuff we're talking about, is supposed to happen before the hearing. So how could the incomplete hearing have anything to do with what I'm talking about?
Well, I think the text of the rule presumes that a hearing for summary judgment is going to be concluded, and all the relevant materials would have been presented to the court to adjudicate that motion. But that's not what happened here.
Would you agree that the defendant was entitled to a complete hearing, a fair and complete hearing on the summary judgment? And they didn't get that?
I think I acquiesced to that point earlier.
Why wouldn't we give them a hearing now, then? We're not going to tell the trial judge to give them their hearing.
Because if you look closely at the affidavit that they submitted, it simply did not create the genuine issue of material fact necessary to extend it to another hearing.
The judge didn't consider the affidavit they submitted. You want us to review it and consider it?
No, granted, the judge ruled that he wasn't going to consider their affidavit.
Based on your client's arguments.
Right.
It was untimely, which is not accurate.
Well, based on the affidavit itself, it simply didn't create a genuine issue of material fact. That's, if you look at the affidavit itself, it simply did not.
So you believe that if the trial court had considered the affidavit and had not considered the unanswered admissions, you still would have won that hearing?
I think so, yes. Yeah.
But that requires us to guess at whether or not the trial judge would have seen it that way.
Well, I think it asks the court to look closely at the affidavit and determine whether or not there is a genuine issue of material fact. For the defendant to...
What's our standard of review, counsel?
De novo, yes. So with a de novo review, you can assess for yourself whether or not there's a genuine issue of material fact. And for the defendant to come forward and say, as Judge, you noted earlier, I don't recall ever contacting them about changing my address for notices. That's not a genuine issue of material fact. That's not a matter in dispute.
That's just establishing a lack of knowledge either way.
Right. Had he come forward and said, I never contacted the bank in any way, shape, or form to change my address, that would have created a genuine issue of material fact. And then I would say...
Does it create reasonable doubt?
Well, doubt about his memory, maybe, but...
About whether or not it occurred?
Well...
Because you didn't actually submit the written request to change the address, right?
Right, that was not part of the record. Yeah. An alternative business record was submitted. And I think you also have to give some weight to the fact that the notice itself was attached to the original complaint. In fact, if my memory serves me, I think there was only one complaint filed. And so there's no question that a notice was sent. The question is whether it was sent to the right address. And on this point, the defendant admitted that his business address is the address to which the notice was sent.
Well, how does that matter if the note and mortgage require any change in that address to be done in writing? You say that's a right that the bank had that they can waive, but it's also a right that the defendant had. There were two gentlemen on this mortgage. You don't want one change in the address without the other one knowing about it. So, I mean, it's required to be in writing. You concede it wasn't in writing or there's no proof it was in writing. Who cares if there's a screenshot that says somebody called in? The whole purpose of the writing requirement is so that we don't rely on screenshots.
Well, you may rely on the screenshot. That's part of the record. It was part of the evidence that was presented. So it's not like there was absolutely no evidence whatsoever. There was something in the record to support the notion.
Counsel, you know, Judge Harris's question is related to the writing, and the documents specifically require a writing. My understanding of your argument that you previously made was that the writing requirement is a provision that the parties can waive if they choose to do so. And so therefore, if the defendant had called in and asked to just change the address over the phone and the bank was okay with doing it that way, the parties had therefore potentially waived it, is what you're saying.
Yeah, and keep one thing in mind also.
Did you have to establish a waiver, though, in your affidavit? In other words, did you also have to have a paragraph in there that said, hey, you know, we didn't comply with, there's no writing here, but the defendant called in and the parties agreed to waive the writing requirement?
I'm having difficulty with that question because I don't know that we necessarily have to establish waiver. We merely set forth what occurred, and what occurred was the defendant, Wardell, contacted the mortgage company, informed them.
But you didn't set forth what kind of contact it was. Was it a writing which would have complied with the mortgage documents? Or was it just oral communication which would not have complied with the documents, right?
I'm afraid I can't answer that. I don't know if it was oral or
We just don't know.
Yeah,
Right.
we just don't know.
But they raised that at least in their affirmative defenses, so is that a material issue? They're saying we never gave written notice to change the address. You're saying, well, they gave us notice. Is that an issue that needs to be resolved, other than by summary judgment?
I don't believe that was the case. What they're claiming is that they never received the notice at the property address. We know that's what they asserted because that's plain as day in their affidavit.
Well, and that's a true statement, right? You acknowledge they never received it at the property address.
Correct.
Okay.
No dispute with that. But we certainly dispute the notion that they didn't receive the notice because.
I don't think they ever alleged that. Do they allege they never received it?
No, they only allude to not having received it at the property address.
The mortgage entitles them to rely on receiving it at the property address.
But, when I looked at this and saw their arguments in their initial brief, I couldn't help but come away with the notion that that assertion is somewhat disingenuous because to never make any mention of having received the notice at the business address, which was where it was sent, it's like I'm not going to go there. I'm not going to inform the court. I'm not going to be candid with the court that I did receive the notice, but I got it not at the property address. I got it at our business address.
And is it their duty to come forward with evidence at summary judgment when you're the movant?
No, generally speaking, no, unless we present sufficient evidence to establish the absence of a material issue of fact, then the burden shifts to the other side to step forward.
That's your time, counsel.
Thank you, Your Honor. We would ask for affirmance of the order appealed from.
Thank you, sir.
Your Honor, concerning your questions about what was raised in the initial brief, at page 29 in our issue 2 discussion, we raised the question of the court issuing a final order in the case in which it had considered, and we listed 6 items, number 4 of which was considered unresponded to requests for admissions against appellant for which appellee had given appellants an indefinite extension to respond. And then at page 30.
That's in the context of the extension to respond, not in the context of 1.510, you didn't give me notice.
It's in the context of whether or not there was, whether or not there were material issues of, genuine disputed material issues of fact.
Yeah, you're looking at a very, very broad argument, obviously, that whether there were issues of fact, but on the specific argument, whether the court erred in considering the request for admission, your specific argument in the brief is only, and again, I'll ask you to point me to where this is, where you make the other argument, but it is solely that the trial court erred in considering those because you had an extension of time.
No, Your
You did
Honor.
not. Well, show me where.
Page 33.
Okay.
A sentence that reads, the supplemental memorandum attempted to include summary judgment evidence which had not been identified in the motion for summary judgment.
That's a statement of fact. That's not an argument. There's no Rule 1.510 there. You didn't argue that you were required to have prior notice and that therefore it's reversible. That is still within the context of the fact that you didn't have, the fact that you had an extension. And in fact, if you read the rest of that paragraph, it clearly is within the context of the extension.
I can only point out to I think that we raised the issue adequately in those two places the court had asked, and I just wanted to point you to that.
On page 33, you're referring to the last paragraph?
Yes, sir. Okay. In connection with Mr. Wardell's affidavit, in addition to the notice provisions, he outlined in some considerable detail the events which had occurred regarding his co-borrower, Mr. COURSON, and his continued attempts to work with the bank regarding refinancing and how he was sent from one place to another, and over a period, he was told he had to buy out Mr. COURSON's interest in order for this refinancing to go through.
How does that relate to the foreclosure?
Because he was ultimately told by the bank when they made an offer to him regarding financing that they could give him a better deal. The quote on page 323 of the record is, "If I wasn't making the payments, you could give me a much better deal." The offer responded, "Yes, absolutely." And so it relates to the affirmative defenses, which talked about fraud and the inducement, and talked about estoppel issues regarding the bank being now, or having to answer those questions regarding their misrepresentations to Mr. Wardell regarding the payments on the ongoing payments on the loan and refinancing.
The ongoing partial payments, right?
I think the
He wasn't making full payments when that alleged statement was made, correct?
I think he was up until that point. I think it was at that juncture that the payment issue arose.
He was making payments for himself and for his
For quite a while.
co-owner?
Yes, sir. For quite a while. So on the basis of all that we've presented, we would ask the court to reverse for new summary judgment proceedings.
Thank you,
Thank you.
sir.